Hi, this is Michael Carlin, president of Henry & Horn Wealth Management with your Manage the Funds podcast. This is part 2 of everything you needed to know about divorce and the finances behind it. We are pleased to be joined again with Leslie Satterly, partner at Woodnick Law. Hi, Leslie.
Hello.
How are you?
I'm good. How are you?
Well, I'm doing pretty well. Listen, for me, I'm really excited about this. I'm excited about everything financial in general because I'm a nerd that way, but I'm really excited about the divorce part of the conversation because so many clients run into the office and we often see money in transition. And transition could mean a death, a birth, a business sale, these kinds of things. And divorce is one of the most common.
Yeah.
And we see it from both sides. We see it from the spouse that comes in, who's in the know. We see it from the spouse who's not in the know. But what I'm really excited to do today with you is to put forth information for our public, our clients, our listeners to start to begin to understand what divorce means from a financial perspective. So I really thank you.
Yeah, no, I thank you as well. I think it's always good when there's the financial aspect and advice from the flip side for us too, because we have people pop in and they don't understand the finances. So they go hand in hand.
Right. I mean, it is definitely something that is often experienced and not discussed quite often enough. Mm-hmm. So we covered your resume and your greatness in the prior podcast, but Leslie's the best. That I can tell you for sure. And we've had many happy clients that have worked with her and her firm. So we have that track record. We talked a little bit about the marriage and divorce statistics in the prior call, but again, just to reiterate, about half of marriages end in divorce. More specifically, it's about 45.5%. Second marriages, you're looking at maybe 2/3 of divorces, right. 2/3 of those marriages ending in divorce, and then the third marriage is 75% or 3/4 likely.
Yeah.
So with that kind of a track record, why is anyone getting married? Exactly. I mean, we're not going to tackle that
today.
Love
is blind.
Love is blind. Yeah, I don't. Right. So with that kind of track record, it seems silly that we're not having these conversations more often.
Yeah, I mean, I often, say that it's silly that there isn't some kind of required class before you're married about how you handle marriage and finances, but it is what it is. That's where we're at. So, we're left untangling this all once the marriage has deteriorated already.
Right. And often enough, things aren't done in the beginning. So why don't we start in the beginning? Right. Because it would seem to me that most of the time we're involved and most of the time you're involved is probably at the end or it's over.
Right.
Right. And if we can do a public service, it would be providing the education to the listeners of the podcast that it is very beneficial emotionally and financially to do things at the outset. So what should individuals be doing from a financial perspective before they get married?
I think the most important thing, at least here in Arizona, is to understand the concept of community property. So community property in Arizona is any property acquired during the marriage. There are caveats to that or exceptions to that. If you get an inheritance during the marriage, that could be your separate property. The problem that parties run into is that they don't understand that there's these different buckets. There's your separate property bucket that really doesn't end up getting divided and shouldn't be divided in a divorce context. And then there's the community property bucket, which does get divided. So the problem arises when those buckets are poured out and mixed all together. So you cannot be mixing your separate property with your community property. If you do that, it spells big trouble at the end in a divorce. Right. So that is the biggest thing. Understanding your separate property. What did you have before the marriage? If you can protect it and keep it separate, keep it separate. If you can't, you need to make sure that you're documenting how much you had at the beginning of the marriage, the statements, the documents, the financial records. Keep those because you might need them if something happens and a divorce ends up occurring later in the future.
Right. So again, if you come to the marriage and you have savings and investment accounts, those kinds of things. So are we talking about, how do I say this delicately, not rushing to take this investment account that has your name on it and then rushing to put it into a joint account with your new spouse. Is that kind of what we're saying?
Exactly. And it could even be less obvious than that. Let's say you have that savings account before the marriage and you continue to keep that savings account. You don't even add your spouse's name to it, but you start depositing your paychecks in there or a portion of your paychecks during the marriage. That account could become so mixed up between your separate property pre-marriage funds and your community property joint funds that the court cannot figure out what's separate and what's community. It's been essentially commingled, and it's all assumed to be community property in a divorce.
Right. We've had clients that have come in where I'm thinking of one client. She had an inheritance. It was about $500,000 from her aunt, and it was titled in her name, but essentially she got a lot of pressure from her spouse over time to say, I don't understand why we don't put this in our name.
Right.
What's the big deal?
Right.
We're not getting a divorce. And then, so she eventually does it. And in that move of, and then, then had it in joint name, and then ended up, they created trusts, and then they had to change into their trust. And so the divorce came, and she's like, "Oh, well, no, that's just my asset from my inheritance." But it didn't go that way.
Right.
In reality, it didn't. That's not how the asset was split, because it was split in half.
Yeah, there's lots of presumptions that pop up with gifting separate property when you either add someone's name to an account or a financial asset, or again, like I said, you commingle that asset. So you got to be careful about that. And there are certain assets that you really can't prevent that from happening. Think about your 401k. It's not like you're going to stop contributing to it once you get married. So again, that's where documenting how much was in there at the date of marriage becomes vitally important.
Right, because what we're trying to do is take a snapshot at that date of marriage to say, my 401k was X, I got divorced, my 401k was Y, and so here's the difference. And so we're establishing, giving someone half of that difference in Arizona. Is that what I'm hearing?
Correct, yes.
So, goodness. But not a lot of people end up quite practicing that.
Not a lot of people understand that. And then the other thing that I think people need to be aware of when they're entering a marriage is that a lot of times title for property is very, very important and yet misunderstood.
Right.
So how you are owning a house with your spouse will determine how it's divided in a divorce. So really the most important asset that you need to make sure that the title is exactly the way you intend it to be is your house. With a lot of other assets, it doesn't matter whose name a bank account is in. It matters where the source of the money came from. With a house with real property, titling becomes very, very important. People don't understand that.
No. Well, so wait. Let's just spend a minute or two on that. Again, it seems clear to me that a couple gets married, they had nothing, and then over time they go and they buy a house together. They've accumulated assets. They buy a house together. To me, there really isn't much you can do there in terms of giving anyone an advantage over anyone else.
Well, but think about the scenario here where maybe one spouse has bad credit. And so they can't or they don't want to be on the mortgage because they're going to get docked with interest rate or whatever else.
Okay.
So the parties are looking at getting a mortgage in one person's name. The title company might say, okay, why don't we do this as the house and someone's sole and separate property? They're married, but it's their sole and separate property.
Okay.
The other spouse says, okay, we're just trying to qualify and get a better rate on our mortgage. I'll sign this disclaimer deed over to you right now. Guess what? That money that bought that house was community in nature, and the person who signed off on the house, who said, I don't have any interest in it because of a disclaimer deed or a quitclaim deed, just gave away that asset to the other spouse.
All just to save some money on mortgage interest.
And they had no idea they were doing that.
That makes me very sad.
Yes.
That makes you sad. And can those things, okay, let's say you're the spouse who did that. Is it too late? Is it over? Can you unwind stuff like that, or you're fighting an uphill battle?
You might be fighting an uphill battle, unfortunately. There is an out because you could argue that since that house was titled, there's still community monies that went to pay down the mortgage and the principal. So there's a community claim to equity in the house, but the actual characterization of the property will probably be separate property.
Right. Well, can I ask you a question? What if, we've got a couple that it's a second marriage, one spouse owns a house, the other spouse then moves into the house. Are there rules that you would give that spouse who owned the house in order to make sure that that property stays on their part of the sole and separate balance sheet.
Right. So obviously, number one, be careful about doing anything with title. Keep it in your sole and separate property name. Don't do anything to transfer it over to the community. The second one, if you want to try and prevent any kind of a community interest claim, you're going to have to see if you had enough sole and separate pre-marriage assets in a bank account to be paying the mortgage from there instead of from a new bank account or from wages or income earned during the marriage paying down the mortgage. I mean, that's really the issue.
Oh. So we're saying, though, that in that case and situation, oh, no, I owned the house before the marriage. Yes, it had a mortgage on it. The mortgage is just in my name. But my wages that I earned while we were married, that was community property.
Correct.
And I'm using that community property to pay the mortgage. Oh, no.
Right. So it creates the ability for the spouse to be making a claim for community interest in in basically the reduction of the principal in the house and the growth of the equity in the house.
Right.
You need to balance whether or not it's worthwhile to be using your separate property funds to do that versus a potential community lien theory on it. Because essentially, if you're using community lien theory, that's the technical word for making the claim on the equity in the house.
Judge pro tem.
Yeah.
Okay. What's this community lien theory? What's that?
It literally is that, it's a separate property asset, but the community has some kind of claim or lien on the equity in the house based upon what the community has contributed. And there's specific math formulas based upon case law that determines exactly what that is.
Oh, goodness. All right. Well, so we're also, again, before you get married, we're going to want to make sure that you are having financial discussions similar to whether or not you own your own business, like the same podcast, but you're going to want to have the good, clear, plain discussions about finances and having a discussion. Is this also a prenup situation where you're recommending that be a part of the path?
Right. I mean, I would say the most common instances of prenups would be subsequent marriages. Maybe it's your second or third or fourth. That's very common. Either you own a business or you have significant assets going into the marriage, or you are anticipating or have already received inheritance from family. Those are usually the instances where prenups come into place. But there could be prenups even if both parties don't have any assets and don't anticipate having any assets. They just know that they don't want to have to worry about this in the future if a divorce comes around.
Right. And you're not more likely to get a divorce if you have a prenup. Or has anyone done the study on that?
I haven't done a study. I would like to say, knock on wood here, of the prenups I've helped do, I haven't seen anyone come back around yet to get divorced.
Well, then there's some proof right there. So, again, I want to skip over to the part of the process where, the divorce is approaching. Mm-hmm. And this is usually when someone walks in the office. And when they're walking in my office, some of the things that I tell them to do is I say, listen, we need to get our arms around where you are right now. So I tell people to go, or we end up going in the conference room and going on freecreditreport.com. You go and you grab this holistic list of your accounts, your credit cards, your history, so that you gain a sense and take, a snapshot right now of where your finances are. But there's probably a lot of other things that you would recommend that they do in terms of, okay, we're here, it's happening, and how do we start to prepare? Right.
Definitely trying to get all your documents together and do as much research as possible about what you have is a very, very important first tool. Apart from the credit report, I think the tax returns are a wealth of information. You can see what kind of 1099 income you have, which might lead to interest and dividends on accounts you didn't know about. I mean, there's just a lot of information that you can get from tax returns. So if you can grab some of those, I highly recommend getting that. Other than that, you do want to start thinking about, okay, how are things going to happen going forward? If you know that your spouse is the one looking for a divorce, you want to start watching your bank accounts carefully. It is not unheard of that a bank account gets drained right before a divorce is filed because someone is nervous about where the money is going to go. I would never advise clients to do that. That can come back and bite you, in a not so pleasant place later on.
Right.
But you want to watch for that, and you want to watch for an uptick in spending, and you want to see if there's any other abnormal things going on with finances.
I've had client situations where there was a bank account with a considerable amount of more than six figures in it, and then one spouse emptied the entire account out and put it into their own brand new sole and separate account, and the banks let them do it.
Right.
Which the very first time that I saw it happen took me by surprise. I said, wait a minute. How can you take this joint account, take all the money out? This is the money that my client's using to pay bills and to live, and move all that money in. How did?
Right.
I mean, this is craziness.
People should know that in and of itself doesn't mean that money is now off the table for the divorce. It's not. It still is going to be traced and found and divided, even if you put it into your own name. I would caution anyone from doing anything other than removing half a balance. And even then, it can cause problems, like you said, because of auto bill pays that are coming out, trying to keep the peace with making sure that you both trust each other through the process. Because if you want to try and get to an amicable resolution, which I know doesn't always happen, but it's certainly not going to happen if you start monkeying around with the finances.
It doesn't start when you empty out the accounts. That's what I find. So again, the key is gather the data, all kinds of data, tax returns, statements, credit report, all that stuff, and now you're going to find yourself in the position where, all right, I've got the data. I understand some basics, but now you've got to figure out mediation or litigation. Mm-hmm. And we talked about it quite a bit in the prior podcast. So, we heed your words and your wisdom about, mediation being in many cases a better path and litigation in many cases being a little bit more difficult. But so let's talk a little bit about the role of an attorney with mediation and litigation, and kind of on the individual side. This is such a hard process. Help us kind of put this very difficult decision.
It is
together.
hard. And when you have high assets, or you have a lot more assets than the normal run-of-the-mill people, I mean, honestly, going to mediation is still a good option, and maybe might even be a better option there. But I highly recommend that you, at a minimum, have attorney consultation or advice before doing it. I think having an attorney present in mediation is very helpful when you have these more complex issues on the table, just so that you understand the role of a mediator is to help you come to agreements. It is not to give you any legal advice. They cannot give either party legal advice. They are the neutral person in the settlement negotiation.
So a mediator can just say, hey, you guys agree? Right or wrong, you guys agree, I'll just go right ahead. So it doesn't even have to be a perfect resolution.
Right, exactly. They're just trying to get you to come to an agreement. So that's one of the other things that we didn't really touch upon in the prior podcast, though, is that when you have high asset parties, mediation often is the place where you're going to have people who are more experienced in those high asset cases. You go to the judge and you have a judge who has, like I mentioned before, 900 cases. Very, very, very few of those are cases with assets, because they settle before they get to the judge's door anyway. But imagine this. If you are the out spouse and you have a very high income wage earner on the other side, or someone who owns his own business, and you're asking for a spousal maintenance award of over $7,500. Let's say you're asking for $10,000 a month. You are asking a judge who likely makes that same amount of money or less to order you spousal maintenance.
And they're not going to, their context for understanding that situation is challenged. By the way, outspouse and inspouse. Inspouse is the person that that gets that understands the finances. Maybe the primary wage earner. The outspouse is the one that has a little bit less of that. Okay, you're right. So that, first of all, I did not realize that most or a significant number of high dollar cases don't ever hit the judge's desk.
They don't. And that's one of the other things to think about too when you're thinking about where am I filing. I mean, here, even in Maricopa County alone, there's 4 different courthouses. There's one in Mesa, there's one in Surprise, there's one in North Phoenix, and there's one downtown. So there are certain courthouses that likely hear more of the high asset cases than others. If you are even potentially able to file in another county, we've had cases where they have been on the outlying counties where there are no experts, there are no business valuators, there are no forensic accountants. So the likelihood that they have heard or have experience with these types of really complex issues is very, very low. Even finding a qualified mediator in those counties is going to be difficult.
Right. So again, before you get, before you get all excited and charged up to say, I'm litigating, I'm taking this dude to court, I'm taking this person to court, we're gonna battle it out, and I've had enough and I'm hiring a lawyer and I'm not going to go to mediation because I can't. Hold on. I think, Leslie, we're telling you to breathe.
Right.
And this, if you're listening to this podcast, it's the first step to say, mediation has a lot of value in the divorce process.
Absolutely.
Well, goodness. So, now you've gone through mediation, right? And again, we hope that mediation, or you unfortunately went through litigation. We hope that you had counsel at the beginning of that mediation throughout that process. And, before the divorce goes final, there's a lot of things financially that people need to start to do to figure out, the short term, the long term, and all that stuff. I mean, again, one of the things that we would have people do is we would have them use. There's a bunch of different applications. We have one at Henry & Horn Wealth Management, and there's Mint is another where you've got software where you're doing your banking, where it pulls in all your expenses. Because one of the things that we don't want people to be surprised about is your finances may have been very comfortable when married, and then all of a sudden you're not going to be adequately prepared for what's next.
Right. Yeah, I mean, it's the concept of scales of economy. I mean, you have a certain number, a set income that you have, and now you're dividing it between two different expenses. So yes, you absolutely need to understand that. You need to know what your expenses are, and understand that, because that's going to play into potential support issues as well.
It does.
It does.
Because again, I think what we're really referring to here, if I'm not wrong, is that the better you understand your own expenses is going to give you and your support team, your financial team, your legal team, your best effort to explain how much you need. Can we spend a minute or two about that?
Yeah, absolutely. So here in Arizona, there's the concept of spousal maintenance, also referred to as alimony or support. And with that, you have to qualify first. So you have to show that your income or your assets available to you are insufficient to cover your reasonable needs, and or you have a mental or physical disability which prohibits you from working, or you had a marriage of long duration and you're not expected to go back to the workforce.
Long duration is more than 10 years?
In Arizona, there's actually no set year limit.
Welcome to Arizona.
Yes.
Okay.
So it's a little bit up to the discretion of the judge, which again becomes very vital in consulting with an attorney who has experience, because there's no formula, there's no set, if you have this and this, then you're entitled to this. With spousal maintenance, it is all discretionary.
Okay.
Yes.
So what you're doing then is that one spouse is saying, well, listen, I mean, and if you have your stuff in a software, you can say, well, this is what my travel budget is, all the way through to my food, all the way through to my, the utilities, all of the kids' expenses, all that kind of stuff. So the more data you have, and I'm sending you all that data to say, here are my needs, and then you're helping make the case for getting adequate coverage and support.
Right. So if you're able to qualify, then you do look at all of those other factors. What is your ability to make income? What is your spouse's ability to make income? What are your expenses? What are their expenses? How much is the cost of health insurance? Because that's usually going to have to be broken up and obtained separately as well. And on and on. I mean, there's a handful of different factors that the court looks at. So understanding the expenses is huge.
Let's say you're the outspouse. Let's say you're the outspouse. And the outspouse, again, is the person who's not necessarily in the know. Can you kind of help explain a little bit about lifestyle? I mean, what if that person's used to taking 2, really nice vacations a year? Is that just a so what? Is that a so what? Or is there really something to that? And what if that person is used to a certain, they're used to nicer cars? Is that like, so what? You got to get used to something less? Is that what happens, or is there something different?
So one of the factors that the court will look at is the standard of living during the marriage. However, again, you have to understand, if you're breaking up income into 2 people, you're not going to be able to enjoy the same luxuries you did before. So does it mean you have to completely cut out all of that stuff? No. Does it mean you're probably going to have to budget a bit and be a little bit more frugal? Yes. It's hitting that happy medium of having some of that in there, but understanding that if you're asking the court, and again, this goes back to the mediation versus litigation concept. Right. If you're asking for your extravagant car payment to be included in your expenses for spousal maintenance, it might be tough to get a judge to agree that that's a reasonable living expense. Right.
I had one client that had a spouse that said that their annual food need was over $4,000 a month.
Right.
Yeah. And so, well, wow, like, are you training for bodybuilding or no? But it was just a grossed up look back at, all the Whole Foods and all the expensive restaurants you could possibly stuff in there. And stuff like that doesn't hold up always.
Right. It doesn't.
It's actually, in this case, it didn't hold up at all. No. so maybe there are cases where it does happen. When you are, again, you're trying to gather your information, you're trying to figure out what your expenses are and figure out what your next track is. We've got two different kinds of spouses. I mean, in some cases it's a dual income. In some cases it's not. Are there any kind of rules of thumb to help a person figure out, what life's going to look like financially afterwards? Can they count on just half of everything, or is this not quite so simple?
On the assets, I mean, again, as long as they're characterized as community property, then really they can assume it's going to be half of whatever is community property. Again, though, talking with a financial planner and understanding, hey, look, half of everything could mean that a big chunk of this is tied up in retirement assets and might not be available to you right away. Or if you tapped into that, you're going to be paying penalties and taxes on top of it. So how much is liquid versus illiquid funds? How much do you have to live off of? What can you invest and maybe have grow or get dividends or interest in the future? I mean, those are all very important considerations.
Right, and we spend a bunch of time with clients because you'll have investments in businesses that are still forming and are still growing. Like they've invested in a small biotech, or they've invested in something totally new or different. And then there's brokerage account portfolios. Again, some in retirement, some not. And it is a delicate balance to figure out, to say, well, listen, you could be splitting some of these assets, but they may not do you any good, or you may be giving up some potentially very high growth assets as well.
Yeah, or maybe you're not thinking about the tax consequences of the assets that you're receiving.
Right.
Is there going to be capital gains that you have to pay on some of this stuff? Is there taxes that you have to pay that you're not taking into consideration? I mean, those are things that really, if you're not taking that into account, it might look like it's a 50-50 split. You take that all into account and one party ended up getting screwed.
Right. And so, right, and to the same degree, before you say, what, I don't want that this particular asset because the valuation came in very low. The valuation tells part of the story. It doesn't always tell you what that growth prospect is. And so, again, one of our clients was one of the early investors in OfferUp. Mm-hmm. In OfferUp, if you're not aware, it's an app, and it's kind of like eBay, where you can sell things and sell or buy things very quickly and easily, kind of in a very simplistic, free fashion. And the company's exploded.
Right.
But on the valuation of that asset, when that came in for the divorce, it came in pretty low, and our client was the spouse on the other side, because the one of the spouses who was in the know, the incline, said, "Oh, geez, no, I'll go ahead. I'll take this asset, and you don't worry about it, because it really isn't worth anything. We can't sell it." And was encouraging the spouse to just don't worry about it. It's not a big deal. But you really have to have a plan and a team in place to help you evaluate all these things.
Well, and with some of these assets that are really, really tough to value, either because they're brand new or they're so tied up, or you have such a minority interest that really getting any kind of substantial value out of it in a divorce context might be hard. You can think about creative options where you continue to somewhat hold on to it jointly even after the divorce.
Oh.
Yeah. And so then you got to think about all kinds of implications of setting up partnership agreements or otherwise to figure out what you're doing once someone wants to get out of the business or not, or sell their shares. But those are creative types of options that you can consider.
Yeah, well, and again, those creative options are going to come when you hire professional expertise. It's frankly that's a good portion of the value that a good team brings you, I would think.
Yeah.
So some of the things when the divorce happens, and as that process is going, we would encourage you. You got to want to open up your own credit cards. We're going to want you to open up bank accounts just in your name. We going to want you to start to establish credit and get some of these other records and beneficiaries taken care of. Is there?
Right. Yeah. You want to start transitioning towards separating out everything. And there's some areas where you need to be careful. careful too. I mean, before a divorce is started, you have more leeway to do things, such as removing money, such as selling things, such as taking someone's name off of insurance or beneficiary designations. Once a divorce is started, though, you got to be careful. Automatically, what goes into effect is a preliminary injunction. And the preliminary injunction says, okay, parties, neither one of you can do anything to hide, sell, or get rid of any assets while this divorce is pending unless there's an agreement. And you can't do anything to change beneficiary designations. You can't take someone off health insurance. You can't take them off your 401ks or your retirements. So those types of things end up becoming big no-nos. But with some divorce planning, you might be able to do some of those. Again, whether or not it's advisable is a case-by-case basis.
Right. And again, be careful before you start changing beneficiaries too soon. Right?
Well, when you're married, the spouse would have to sign off on it. So that's going to be a big red flag if you ask them to do that.
Right. Well, life insurance, beneficiary things, those kinds of things. So, for older spouses, I mean, we call those gray divorces?
Yes.
So those things are more common.
They are common.
I'm seeing, clients that have been married 30, 40 years getting a divorce. It's just, as shocking as that is and jarring as it is emotionally, we certainly aren't dealing with child custody issues in that case.
We're not. But we are dealing with issues that might delve into, how are we going to pay for expenses for long-term care? Maybe maybe the divorce is happening because there are issues with someone being sick and they're trying to do what they can to protect assets. That becomes an issue. Better planning for how you're dividing up retirement assets. And usually with these older divorces, there's pensions involved. Obviously, Social Security is already in play. So there's different considerations that come into play when you have divorces with older couples.
Right. And so that is where forecasting what your finances are going to look like and how they evolve. I mean, listen, it's important for everyone. It's extraordinarily important in those cases and situations so that you can start to understand given the finances that you have, because again, if you're in a great divorce situation, your ability to work a long period of time is reduced.
Right.
Right. So what you have and what you see in front of you is critically important that you manage it and understand it correctly. So, so I see that. I see that issue. I also see issues where you've got people where they may have to return to the workforce.
Yeah.
Yeah,
or they had retirement plans and they need to be postponed now. And that's an unfortunate consequence of this because, again, you're figuring out how to support two different households at that point. And there might still be a qualification for spousal maintenance.
Right. And what is, in Arizona, let's just refresh, what does the prototypical spousal maintenance situation look like in a great divorce? Is it half the years you were married? Is it still...
So, when you have a long-term marriage and older couples, there's one of two things that I think generally happens. One is that if you're nearing the age of retirement, they might give a duration of spousal maintenance to retirement age and then assume at that point they are going to be drawing on their retirement assets and have Social Security income. The other common order might end up being that it's an indefinite term, and that sounds very, very scary because it's open-ended and it sounds like for forever.
No one likes
that.
No.
But what it really means is we don't know what the end date's going to look like. So the person who's paying the obligor will have to come back to court and ask the court to modify or terminate it once they've either stopped working or something has changed with their ability to pay. The reason why they do this, again, I mean, it's hard. Even if you put then a duration of half the marriage on a 40-year marriage, that's 20 years. I mean, they might be in their mid-90s at that point, so that doesn't make sense. Which
is why you tie it to how long, if they're continuing to work.
Exactly. Yep.
Okay. But you got to go back to court to prove that you're not working?
If you end up getting an indefinite term, that would be the problem. So negotiating, and sometimes it's better knowing the duration than not knowing the duration.
Right. And you certainly, and you probably run into a situation and say, well, that's it, I retire, and I'm retiring now. I mean, I can only imagine some of the games that go on with all of that stuff. Holy cow. All right. So I think what we've done is we have broken down what you should be prepared for emotionally, mentally, and financially should you be preparing for a divorce. So Do you want to help sum it up in terms of what people need to do? I mean, we got all kinds of different things, beginning, middle, and end, and all these different components.
Yeah, get your support system in place.
Right.
Your support system can include emotional support as well. I mean, I am not a counselor. I don't provide the mental health aspect, but that comes hand in hand with a divorce. Pay someone cheaper than me for that.
Right. So step one, we got to get your team together.
Get your team together. That also includes looking at your finances, understanding your finances. What do they look like as far as assets being divided? What do they look like as far as income? What are we talking about for support? Figure all of that out. At least having an understanding of what's there helps tremendously with the discussion of how we're dividing it.
Get information, get the data.
Get information, get the data. And then make sure you're consulting with all the right people. I mean, it could be the tax attorney. Sometimes it could be a bankruptcy attorney. Sometimes it's a corporate attorney. Sometimes it's a financial advisor. I mean, you never know who you're going to have to talk to in a divorce context.
And I just, for me, the last topic I'd love for you to touch on. For me, it's the thing that's non-financial, but it's one of the things that I have found in my experience with clients is that the mood of the situation, the way you communicate with your ex-spouse, how you handle yourself, that may end up dictating how expensive and how financially difficult and how financially and emotionally demanding it is. So in terms of just the emotional aspect of it and your own behavior, any words of wisdom there?
No, it's a big factor. So obviously it's emotional, and you might want to leash your anger on the other side many times. It's rarely ever going to turn out the way you want it to. I mean, you probably won't even feel better at the end of doing that.
Right.
So keep things civil, keep things straightforward and to the point. You don't need to be dragging in emotions in this, especially when you're talking about the divorce litigation. That's not the place to do it. You are really looking at this from a business point of view.
Leslie did it again. You did it again. You're amazing. Thank you. Leslie Satterly, Woodnick Law. You can find her at woodnicklaw.com. Again, thank you so much for listening to the Manage to Fund podcast. We appreciate it, and we will talk to you soon. Take care.
Thank you.